Hey everyone, and welcome to this explainer. If you're gearing up for the National Professional Practice Examination, or honestly, if you're just a professional wanting to really understand the legal guardrails of our industry, you are in exactly the right place. Today, I'm putting on my NPPE instructor hat. We're going to completely pull back the curtain on how exam designers build these contract law questions, how they try to trip you up, and most importantly, how you can spot the correct answer with absolute confidence. We're looking at a fascinating, real-world scenario today that perfectly captures the tension between what's written on a piece of paper and how people actually behave out there on a project site. Okay, let's dive into this. Here is our 5-step masterclass structure for today. 1. The contract exam challenge. 2. Identifying the core topic. 3. The underlying legal theory. 4. Correct answer and traps. And 5. Terminology and final takeaways. All right, starting us off, Section 1, the Contract Exam Challenge. I want you to put yourself right into the test taker's mindset for a second. The clock is ticking down, and this exact scenario pops up on your screen. A client waives strict compliance with contract milestones repeatedly, then suddenly enforces them. Which doctrine applies? Take a second to really picture this in real life. You're a contractor, you have hard deadlines. You miss a few, but the client just smiles, waves a hand, and says, "Hey, don't worry about it, just keep working." And this happens again and again. You get comfortable, right? And then, completely out of nowhere, you miss a milestone by a single day, and the client just slams his fist on the table and says, "That's it, I am enforcing the contract to the letter, you are penalized." Now, that feels inherently wrong, doesn't it? But what's the actual legal mechanism that deals with it? Well, the exam gives you 4 options to choose from. Option A, novation. Option B, frustration. Option C, fundamental breach. And option D, waiver and estoppel preventing abrupt enforcement without notice. Now, if these options feel like a giant bowl of legal alphabet soup, do not worry. It is completely normal for these terms to feel incredibly dense at first glance. Our entire job today is to untangle them so clearly that you will literally never second-guess them again. Moving right along to Section 2, identifying the core topic. So where does this fit in? This question falls squarely under the umbrella of engineering law, specifically testing contract enforcement. You see, when an exam designer writes a question like this, they're not testing your technical math or engineering skills. They're actually testing your professional survival skills. They want to know if you understand how contractual obligations are managed, altered, and legally upheld in the messy, unpredictable reality of day-to-day practice. Contracts are rarely executed perfectly. Delays happen, milestones shift. This specific topic tests whether you know the real legal consequences of how you manage those shifting realities. Which brings us to Section 3, the underlying legal theory. So, what is the examiner actually trying to measure here? It's your grasp of equitable doctrines. Now, in law, equity basically just means fairness. The courts recognize that sometimes rigidly applying the strict, black-and-white text of a contract can lead to a profoundly unfair result, especially if the two parties have been acting entirely differently in reality. The exam designer wants to see, can you recognize when the law will step in to prevent an unfair surprise or an ambush in a business relationship? This really gets to the heart of the conflict. On one side, we have the client's past behavior, repeatedly waiving compliance with milestones. They have clearly established a pattern of leniency. But on the other side, we have their current behavior, suddenly enforcing those exact same milestones without any warning whatsoever. It's essentially the legal equivalent of the boy who cried wolf, just in reverse. If you constantly tell someone that the rules don't apply, you absolutely cannot suddenly trap them by claiming the rules are absolute. The law really frowns upon this kind of hypocrisy, mostly because business fundamentally relies on predictability. Let's actually walk through the chronological flow of how this unfolds legally. Step 1. A contractual right exists. The contract clearly states the milestones. Step 2. The right is repeatedly ignored. The client actively chooses not to enforce those deadlines. Step 3. The contractor relies on this leniency. They naturally adapt their schedule based on the client's relaxed attitude. And Step 4. Sudden enforcement is legally prevented. Because the client relied on that leniency, the client has temporarily lost the right to drop the hammer without giving a fair warning first. This simple, step-by-step logic is exactly what you need to hold in your mind for the exam. All right, Section 4, correct answer and traps. The correct answer, as provided by our source material, is option D, waiver and estoppel preventing abrupt enforcement without notice. This option is the only one that perfectly captures the chronological steps of fairness we were just talking about. It correctly identifies that the client waived their rights, and because of that, they are estopped or prevented from abruptly enforcing them without giving the contractor a heads up that the honeymoon period is officially over. Now, we have to analyze the traps the examiners set for you because they are sneaky. Let's look at the incorrect options. Option A is novation. Novation means replacing an old contract entirely with a brand new one. The trap here? The examiner is hoping you think that ignoring milestones essentially wrote a new contract, but that's false. Mere leniency doesn't tear up the old agreement. Option B is frustration. Frustration occurs when a totally unforeseeable event, like a meteor striking the job site, makes the contract utterly impossible to perform. The trap is confusing a client's voluntary choice to be lenient with a genuine impossible situation. It wasn't impossible to enforce the contract. The client just chose not to. Finally, option C, fundamental breach. This means a core failure of the contract. The trap here is deadly for unprepared candidates. An amateur might look at the scenario, see missed milestones, and instantly think, aha, missing a deadline is a breach of contract. But that completely ignores the first half of the sentence. The client repeatedly waived compliance. You cannot be guilty of a fundamental breach for being late if the client literally just told you it was okay to be late.
Almost done. Section 5. Terminology and final takeaways.
Let's lock in this vocabulary so you never forget it. First, waiver. A waiver is the voluntary relinquishment or surrender of some known right or privilege. In our scenario, the right was strict compliance with the project schedule. By repeatedly ignoring those milestones, the client voluntarily surrendered their right to complain about them in that moment. So the crucial point here is that a waiver requires an intentional act, even if that act is just a consistent pattern of ignoring a rule. Next up, we have estoppel. I always like to think of estoppel as a legal shield. It's a legal principle that prevents or stops someone from asserting a right that contradicts what they previously said or did. Because the client waived the milestones, that was their previous action, estoppel is the shield the contractor holds up to say, whoa, you can't penalize me now, that contradicts your past behavior. Estoppel and waiver almost always ride together in these scenarios. One party waives their right, which automatically arms the other party with the shield of estoppel. So what are the absolute core takeaways you need for the NPPE? First, past behavior shapes future rights. A contract is a living document influenced by how the parties actually act. Second, you cannot ambush a partner. The law protects parties from unfair surprises. Third, and this is a highly practical point, if a client does want to go back to the strict schedule after being lenient, they can, but they must give reasonable notice to reinstate strict compliance. They have to explicitly say, hey, moving forward, the free pass is over. And finally, remember that fairness dictates contract enforcement through these equitable doctrines. I want to leave you with a final thought to ponder for your exam and for your career. If our professional ethics inherently require fairness and integrity, shouldn't the way we enforce our contracts reflect the actual reality of our working relationships, rather than just blindly following the ink on the page? The law definitely seems to think so, and as aspiring professionals, we absolutely must too. Thank you so much for joining me in this explainer today. Keep this framework in your back pocket, and you're going to navigate these contract questions with absolute clarity.